Assalamualaikum warahmatullahi wabarakatuh, and a good day to everyone. We're going to continue with our topic on sources of law, and we are still on the part of unwritten law. So we are moving on to the second part, which is case law, doctrine of binding judicial precedent, or doctrine of stare decisis. Now I'm recording from my iPad. Reason why is because I would like to show you. It's easier for me to show the structure later on the court structure. Okay. Now first and foremost, you need to know what is case law. So if you look at the definition given on the slide, it says that judicial decision of the court which is referred to by the later court as a guide to decide future cases with similar facts and situation. So if case A has been decided by court in Seremban, for example, and there come another case in Johor Bahru, similar facts, almost similar situation, chances are that the decision will be followed or something like that. Okay. And case law becomes the source of law according to the doctrine of binding judicial precedent or doctrine of stare decisis. Okay. And then we continue again with judicial decisions are court decision or are also called as judge made law. Why is a judge made law? Because it's a decision made by the judges. They are unwritten. We call it unwritten because it's not in proper codified document. So basically all these judicial decisions they make up most of the common law of a country. Now, judicial decision form part of the law of Malaysia through this doctrine of binding precedent, meaning whatever has been decided earlier, and if similar facts and situation arise, we're going to follow the decision, or what we call stare decisis. Another meaning for stare decisis is that stand by what has been decided. Okay. Next, we move on to what are the types of precedent. There are two types, which is first one, original, second one, declaratory. So original means a new made law or can be said as a case that has not occurred before. So it can be used. Sorry for this. I think there's some slides shown on the right. So new original precedent. So is actually a new made law or can be said as a case that have not been occurred before, and it can be used by future court to decide when the same matter arise. Okay. Then declaratory is actually previous cases or decision that may be taken as example in deciding if the same matter or situation arise. And then every decision reached must be reported together with the reason for deciding, or what we call ratio decidendi. Now you might realize there are a lot of new terms for you people, especially for these diploma students. So just please bear with me. You will understand later in detail what are those terms mean. Now ratio decidendi are what we call reasons or principles of deciding, or what are the reasons that they decide they make such decision in a particular case. And obiter dicta what are things said by the judges, and it's not relevant to the case but can be a reference if the same thing, okay, meaning the comment arise in the future. So it does not form part of the ratio decidendi but may be cited in later case. So obiter dicta is something like what did the judge say? Okay, the judge's statement. Now, this process of judicial precedent, so how does it come about? So after arguments heard before a judge, the judge will reach his conclusion and decision, and we formulate and apply legal principles, which is the law. So the judge will give reasons for reaching his decision, and in these reasons lies the ratio decidendi, or the reason behind the decision, or the legal principles behind the decision. So the ratio decidendi of an earlier case may bind and become a precedent for deciding other cases or similar dispute in future. Now, let me just explain before that the courts, the courts, some sort of the process in court itself. Okay, let me just start off with a very basic thing. I believe I've already explained for benefits of everyone who are new to law. This is the most simplest method of explaining what is it. Now, first and foremost, let me just explain the title. Okay, assuming the case name is Muhammad, just here. Okay, Muhammad Ali bin, okay, who else? Muhammad Ali bin Ahmad. Okay, he actually claimed damages from Maimunah, okay, binti Omar. Okay, now you might find, let me just add a little bit here. That's this one. Okay, let me just use this first. 2018. Okay, 2 MLJ. Okay, let's say 27. Okay, Muhammad Ali is, assuming this is a civil case, Muhammad Ali is the plaintiff. Maimunah Draman is the defendant. Yeah. Okay. And what is this? Okay. This is the year the cases was decided. This is the volume. Okay. This is the journal. And this is the page. Okay. So how we read this citation? This whole thing is what we call citation. Citation of a case. Okay. Now how do we read? Muhammad Ali bin, in the case of Muhammad Ali bin Ahmad and Maimunah, this is some people call it versus, but actually is and. You will see in some other of my videos, I explain this part of Y is V, and we pronounce it as N. So if we were to write, we write it as B, but when we pronounce it, we pronounce it as N. So in the case of Muhammad Ali and Maimunah binti Omar, reported in 2018 in volume 2 of the Malayan Law Journal at page 27. Okay, this is the case name. Yeah. Okay, and then how did the procedure comes about? So when a plaintiff sue a defendant, okay, there will be a matter will be referred to, let's say, High Court. It was referred to High Court, and assuming a plaintiff sue defendant for more than, say, 3.5 million. Okay, 3.5 million. Assuming is for a breach of contract. Okay. Let me make a bit darker. Yep. Okay. Okay. The matter goes to court. There'll be a lot of process before that. I will not go through detail, and there will be a trial. Okay. And during this trial, there will be witnesses here, plaintiff witnesses, okay, defendant witnesses. So assuming there's one witnesses, plaintiff witnesses 2, plaintiff witnesses 3, and there's only 1 or 2 witnesses of defendant. and assuming there's plaintiff counsels, yeah, the lawyer, and there's also defendants counsel. Okay, there'll be examination. Okay, there'll be examination by the plaintiff counsel for their witness, and there'll be cross-examination and re-examination. I would not deal into that, but for your purpose, we're going to go into that later. Now, after asking all these witnesses, then the plaintiff counsel, they will submit their case. Okay, they will submit their they will make their submission. Okay, they will make their submission. Yeah, they will make submission. Okay, and then defendant counsel he will also make submission. Okay, to the court, and then both submission will be considered by the judge. Okay, and then looking at all those submission, there will be documents as well. Okay, right, these are the document, and the judge will come up with a judgment. Okay, judgment. These are the decision of the court. Okay, so we look back here. Okay, after arguments heard before a judge, the judge, in reaching his conclusion and decision, will formulate and apply legal principles, which is the law. The judge will give reasons for reaching his decision, and in this reason lies the ratio decidendi, the reasons behind the decision or the legal principle behind the decision. So whatever earlier case may be bind before this particular judge make their decision. Okay, and then if the precedent comes from a court superior in hierarchy, okay, then they will follow. And if the precedent is ignored by the lower court, the decision of that court is wrong and will be overturned on appeal to a higher court. Okay, now, okay, remember just now this is a high court. Okay, now assuming when plaintiff sue defendant, okay, plaintiff wins, and then defendant not satisfied, defendant can appeal. Yeah, assuming defendant appeal. Okay, so this one is that the high court. Okay, and when he appeal, defendant become the appellant. Okay, this is the original defendant, and plaintiff become the respondent. Okay, this is the original plaintiff, and at this stage, this is the court of appeal. And assuming again at this stage the defendant lose his case, yeah, he's still not satisfied, he can also further appeal. Okay, they can also further appeal to the high court. So this is still the defendant, this is the respondent. So whoever respond the appeal will be called the respondent. So this is at the federal court. So federal court is the highest court, and whatever decision is made by all the lower court. Yeah, okay. So that's it for the process. Yeah, okay. Now, if we look at the reason why there is precedent, yeah, okay. And there are two types of precedent. Binding precedent, you follow prior or previous decision of the same level, or it can be persuasive precedent, local superior court borrowed from other Commonwealth countries, yeah, with similar law in Malaysia. Okay, and why do we have this judicial precedent? Because of the doctrine of stare decisis. Because of this precedent is very important to standardize the law and uniformity, also to prevent uncertainty of the law, prevent injustice, and in fact, to achieve consistency. So how do you apply this precedent has been accepted by the court? And in fact, in the case of Public Prosecutor and Datuk Tan Cheng Wee, the court says that it is however necessary to affirm the doctrine of study sciences, which the federal court accepts and unreservedly, and which is expected that the High Court and other inferior court in the common law system should also follow the precedent. Okay. Now, you need to understand this one first. Okay. The court structure. If you look at the figure, you can see that pre-1985, the highest is Judicial Committee of Privy Council. Alright. At that particular time, this is the highest deciding case, and they actually formally acted as the High Court of Appeal for the British Empire and British territories overseas and other independent Commonwealth states. Yeah, and then below that they have this Federal Court of Malaysia and High Court of Malaya and Borneo. But then in 1985, there has been changes in the court structure. Now there's only Supreme Court and High Court of Malaya and Borneo. And again, in 1994, there was a change in the court structure. The highest is the Federal Court, Court of Appeal, and High Court of Borneo is called High Court of Sabah and Sarawak. And if you notice, beginning of 1985, we are no longer sending our cases to the Judicial Committee of Privy Council. So Privy Council is no longer the highest appellate court, where in 1985 to 1994, Supreme Court is the highest appellate court, and post 1994, Federal Court is the highest appellate court. Yeah.